Now we begin with session 1 of the conference. The theme of this session is exploring critical perspectives in criminal law. We have Professor B.B. Pandey sir as the key speaker and moderator of this session. Professor B.B. Pandey sir has worked with institutes of national and international repute in various capacities such as lecturer, Faculty of Law, University of Jabalpur, senior lecturer, Faculty of Law, University of Rajasthan, Professor of Law, Lucknow University, Visiting Professor, School of Law, City of University, Hong Kong, Professor of Law, Campus Law Center, University of Delhi. He has also held the Human Rights Chair Professorship of National Human Rights Commission, New Delhi. We have Professor G.S. Bajpai sir as the panelist of this session. Professor G.S. Bajpai sir is the Registrar of National Law University, Delhi. He serves as the Professor of Criminology and Criminal Justice at NLU, Delhi. He is also the Chair Professor of K.L. Arora Chair in Criminal Law in the University. Before this, he was serving as the Professor and Chairperson at the Center for Criminal Justice Administration, National University, Mumbai. He has also held several positions at the Indian Institute of Public Administration, Bureau of Police Research and Development, Punjab Police Academy, and the Department of Criminology and Forensic Science, University of Sagar, MP. Then we have Mr. Vishwajit Chaudhary as the speaker for this session. Mr. Vishwajit Chaudhary is the Assistant Professor and Assistant Director for Center of Penology, Criminal Justice and Police Studies, Jindal Global Law School. There will be 3 presentations in this session, and each presentation would be limited to 20 minutes each.
I think I will request Dr. Vishwajit to make his presentation, and I will come in the end, followed by Professor Bajpai, and I'll come in the end.
Professor Pandey, Professor Bajpai, and all distinguished guests here. I'm going to break all rules of public speaking, and in fact, going to start with an apology. Apology because my thoughts are going to be very scattered, and to use a technical term, a very technical term used by Professor Bakshi this morning, they might come across as bakwas, but trust me, by the end of it, it should hopefully make some sort of sense. The reason why they're so scattered is because very rarely you get such level of brilliance and such level of intellectual capability in, per square meter. I don't think that exists in many other places, so that's why my thoughts are very, very scattered. I'm going to start with a very simple thought, and that thought is that the criminal law system or the criminal law process is going through a deep crisis. What do I mean when I say that it is going through a deep crisis? In the morning, we were reminded how it might not perhaps capture the essence of criminal law if we refer to it as a system. So I am going to refer to it rather as a process, starting from investigation all the way, going through your investigation, inquiry, trial, all the way to what happens after conviction or acquittal. Now, if we start right from the beginning, we see that crimes have to be either reported. There are, of course, other methods of doing it, so water magistrates taking cognizance, so on and so forth. I'm not going to bore you with that, but crimes have to be reported in one way or the other. Who investigates it? It is, of course, the duty of the police to do that. After that, of course, it goes to the judicial trajectory, and finally it ends up in something called prisons. Now, if we look and if we break into the different kind of processes that the justice system goes through, it becomes all abundantly clear that it is a deeply, deeply broken system. Let's start first with the police. Police, as we all know in this country, is suffering from deep, deep problems of legitimacy. Of course, the police forces do a brilliant job in most of the scenarios, but cases like Lalita Kumari, cases like Mathura rape case are still haunting us today, and to say that people trust the police is something that will take at least a few decades. Why this happens, there are various thoughts, and one of them, of course, being, which I think Professor Pandey in the last conference had just hinted upon, is perhaps the colonial setup that we've got. Rather than respecting and rather than trusting the police, our initial reaction is to simply be scared of the police. How many of you as children were ever told, "Chup kar jao, police wala aa jayega"? I was told that, but I came from a family of lawyers, so that excited me more than it scared me. But the point being, we still associate the police with something that we should be scared of. It's a very, very colonial setup where the idea of fear rather than the idea of respect and trust are prevalent. Then we talk about other investigating agencies. Let's start with the CBI. All I'm going to say is quote the Supreme Court saying CBI, caged parrot, and that, my argument, is made in that sense. We then come to the courts. And if you look at the courts, they have been criticized by every possible stakeholder in them. Let's start with the academics. We've done it time and again. I've done it time and again. We then come to practitioners. They've been doing it to the extent that for the first time for justices of the Supreme Court, they come out and say that this is times of crisis. And then we talk about the layperson or the pseudo-layperson, and we do not need to go any further than look at, for instance, the recent 2 books by Mr. Arun Shourie, which give in gruesome detail how frustrating the judicial process can be. It takes 20 years for us to find out who killed the black buck. It takes us even longer to find out who killed a person. And what is the message that we are sending? These kind of things lead to deep, deep problems of legitimacy, and that is what plagues our court systems. We of course have to look at our so-called brothers and sisters in law. Lawyers are known for if you start following the depictions of lawyers right from the 15th century, I think Shakespeare once said, let's do one thing, let's kill all lawyers. And if you go around asking, of course, non-lawyers, the thoughts today will probably not be very different. The reason that law has been seen as a preserve of this very, very limited profession who manipulate the law. And as we were talking this morning, you look at the delays in the justice system. You see that there are some cases, for instance, Shiv Kotex, Ram Rameshwari, and these are just some of the cases where you see the sort of delay that has happened 40, 50, 60 years in some cases. I think the most painful and the most unpoetic irony of all was when the London High Court, during the Taj, you remember that case where Taj Hotel Mumbai was under siege. In English, when he jumped out of his building on the express instructions of the hotel not to do so, but he wanted to sue in negligence. He goes back to his own country, which happens to be the United Kingdom. He goes to the High Court there and says, I want to fight the case here because in India I will not get justice. Alternatively, on average, justice will take me 17 years. In the most painful, unpoetic way, the London High Court said that yes, it's fine for you to pursue the case here. And that was an extremely, extremely painful step in our Indian history. We think we've come out of the shadows. We think we've come out of the shadows of the post-colonial past, but it still haunts us. And for a UK court to say, all right, we'll take care of it, you please stay out of it, I thought that was deeply, deeply problematic. And that again, it furthers the problem that we have of legitimacy. If we again talk of lawyers, look at R.K. Anand, what the public prosecutors were doing that. And R.K. Anand is just one case where we see the problems that the prosecutors face. They are supposed to be the officers of the court, but it is not unheard of for people to be overcharged, for people to be undercharged, for unnecessary adjournments to be taken, and dare I say, sometimes even bribery is happening in our courts. The third, and from a critical point of view, perhaps the most important crisis that we have of the legitimacy is the othering of the other. You look at victim shaming, you look at accused or even conflict ostracizing. I say they are both the same thing. When you either victim shame or when you say that the accused does not deserve a fair trial, you see that the people are losing faith in the justice system. What business, for instance, is it that if somebody is lynched in Dadri on the mere accusation that he had beef in his fridge, what business is it to find out where people are justifying saying, yes, it did turn out to be beef? Is that even relevant? And let me also go, I think you might all be aware, there was a rape which happened in Sonipat, and this is High Court judges, and the High Court judges are questioning the girl's promiscuity. They say, and they go to the extent of saying, that a pack of cigarettes and a pack of condoms was found in her room. And these are High Court judges, these are certain High Court judges. And if judges are questioning the victim to that extent, what legitimacy can be claimed? Equally, accused shaming. We are very quick in reacting. We are very, very quick in finding out so-called solutions. While the world is on its way to take capital punishment out, we are more than happy to send our own citizens to the gallows. We don't look at the problem. We look at what we can do as a knee-jerk reaction, and the result is in front of us even after the ordinance was passed in many of the states. You see that rapes have been happening. In fact, newspapers have been reporting them with even more vigor. And that certainly is not the only way of stopping crime. When you link crime only to punishment, you leave everything that is in between, and that is a deep, deep problem, and that leads to crisis of legitimacy. What do we do about it? Well, this is a question that has gone around for a very, very long time, and one of the ways that possibly can be done is to involve the society. How do other countries do it? You look at many of the other countries, you see many, many countries have trial by jury. We've of course done away with it for our own reasons. Trial by jury, let me tell you, I'm not that big a fan of trial by jury. It is often misquoted, it is said as a right. Of course, if you look at either Professor Baker's or Professor Wilson's or any of the historians, you look at their records, juries were not really what we make them out to be. Juries also often do not get the law, so they're not the best of solutions, but that's something which we should reconsider. The second, perhaps more robust alternative is to look at the concept of lay magistrates. Many countries, for instance the United Kingdom, they involve the society where they nominate and they get in some people called the justices of the peace. These are not lawyers, so they will not get into the sort of conversations that only lawyers would have, but their job is to do justice, and that's exactly what they do. But perhaps most importantly, we need a paradigm shift where we as academics, they as lawyers, and the society as us opens up and talks about these things. We need a society where we are not othering the others, where we are not ostracizing the accused or the criminals or the so-called criminals or even the accused or the convicted criminals, any one of them. There needs to be deeper and more holistic engagement, and that needs deep structural shifts. Amartya Sen, of course, in the very famous analogy of A, B, and C, he was asked what is justice. You all, I'm assuming, know about the flute analogy. He says justice cannot always be given as a definition, but where there is injustice, that can be understood, and what we need to do first and foremost is to remove the injustices that are happening around us. I borrow from Arundhati Roy to end my conversation, and this is a quotation from one of her books, which goes as follows: to love, to be loved, to never forget your own insignificance, to never get used to the unspeakable violence and the vulgar disparity of life around you, to never simplify what is complicated or complicate what is simple, to respect strength, never power, above all to watch, to try and understand, to never look away, and to never, never.
The criticalist of UK, Alan Norrie, in his famous book, Law and the Beautiful Soul, that he wrote in 2005, he says that, I'll just quote his 2 lines. The second thing concerns the nature of legal critique, and in particular, relationship between socio-historical and ethical dimension. The idea of beautiful soul is bringing in the ethical dimension in study of criminal law. Criminal law should end up, and here I think Alan seems to be going in a direction which has been opposite to what he thought always in Crime, Reason and History that law also chases an ethical dimension. All human activity is a purposive human enterprise. Criminal law is also to have a soul. And he said that soul is Hegel's beautiful soul. This is the ethical dimension of criminal law. Now, Vishwajit, as a young scholar, is also enamored by that critical dimension. But the bigger question here is, how can we maintain the autonomy of criminal law, which is power-based, which is command-based, which is control-based. The nature of criminal law is such. You have punishment, you have death penalty. You have, if death penalty is not there, you have life imprisonment, you have life imprisonment till the end of natural life, you have pain. It is not only pleasure. This all will have to be worked into criminal law. And then ethical dimension has got to be invented. Our indigenous ethical dimension can be different from Macaulay's ethical dimensions. Certainly, 21st century ethical dimensions can be different. But it will have to have something. If there is crime, either you go in a utopia that is a crime-free society, a Marxist utopia, and state will wither away. ऐसा तो होगा नहीं. But जब तक ऐसा नहीं होता है, till then, you need a criminal law. It's all right that we find 100 flaws. That becomes a kind of Vishwajit, a kind of उसके ऊपर उठना है. A journalistic kind of narrative. ये गड़बड़ है, वो गड़बड़ है, वो खराब है. Critique should not stop there. तो अच्छा क्या है? इसका क्या alternative सोचते हो? In the context of criminal law, हमने बहुत बार सोचा normativity of criminal law or radical alternative to criminal. Normative से radical alternative. दो viewpoints हैं. One is criminal law is a set of norms, criminal law is good, the criminal law is good, the policeman is good. Justice Malimat कहते हैं, you must learn to love your policeman. Malimat committee. तो मैं उनसे झगड़ा करता था, मैं उनसे कहता था, this policeman, unless it changes, no, one day they are doing a lot of good things also. But the question is, normative system of criminal law. What is majority of people today are saying criminal law is a set of powers and rules. Through criminal law, through crime, we assume more power. Whether it is kind of lynching, whether it is kind of rape, whether it is delaying the criminal trials, that is, criminal law is a power resource. उसको वैसे समझो. So we are saying criminal law is a normative system. Though in mind I am impressed by the normative, alternative to normative system, like Richard Quinn. But that alternative should come when? Through a revolution, people's involvement, democratic participation. Stephen Boxett said criminal law is in crisis because of lack of participation of the people. For too long, too many of us have believed about crime through the eyes of the state. हमने खुद crime को experience नहीं किया. हमने state के decision को gospel truth माना. That is the pain. And for being able to understand crime in a democratic frame, You have got to learn the rules of democracy. You have to learn equality, foundational ideas that are written in the Constitution. You have to learn primacy of the fundamental rights over all other things. You have to learn to respect life and liberties. That is foundational. You have to learn that others have right to certain guaranteed freedoms. That is foundational. You have to learn that even an accused has certain guaranteed rights. Even an accused. ये सब सीखने के लिए we have to train our society. I'm still hopeful that that can be done. That civil society, again it is like a law and the beautiful soul. It is a beautiful soul idea that we will have. But she doesn't agree that we have an evil society, not a civil society. I think we should strive towards moving towards a civil society. But that we are not at the moment. We are certainly uncivil. Thank you very much, Vishwaji, but make it little deeper.